Let me start by reiterating that I'm pleased that the New York prosecution is going forward. They brought these charges based on new evidence against Jeffrey Epstein, who is now a registered sex offender, and this is a very, very good thing. His acts are despicable, and the New York prosecution offers an important opportunity to more fully bring Epstein to justice. In 2008, a major newspaper described the Epstein prosecution like this. A Florida grand jury, that is, a grand jury convened by the district attorney of Palm Beach County, had charged Epstein with the lesser offense. At that time, the Epstein legal team was elated. He would have avoided prison altogether. But then the United States Attorney's Office in Miami became involved. Epstein got an ultimatum: plead guilty to a charge that would require jail time and registration, or face federal charges. And that was the week, more than 10 years ago, that Epstein went to jail. Times have changed, and coverage of this case has certainly changed since that article. Facts are important, and facts are being overlooked. This matter started as a state matter. It was prosecuted initially by the state of Florida and not by the U.S. Attorney's Office. In 2006, a grand jury convened by the state attorney, the district attorney of Palm Beach County, reviewed the evidence and recommended a single charge. And that charge would have resulted in no jail time at all, no registration as a sexual offender, and no restitution to the victim. Further, the state attorney's office allowed Epstein to self-surrender and arraigned him the following morning. Simply put, the Palm Beach State Attorney's Office was ready to let Epstein walk free, no jail time, nothing. Prosecutors in my former office found this to be completely unacceptable, and they became involved. Our office became involved. Our prosecutors, as this 2008 article recounts, presented the ultimatum: plead guilty to more serious charges, charges that required jail time, registration, and restitution, or we'd roll the dice and bring a federal indictment. Without the work of our prosecutors, Epstein would have gotten away with just that state charge. Now, many today question the terms of that ultimatum, what's called the non-prosecution agreement. A good prosecutor will tell you that these cases are complex, especially when they involve children, and even more so in 2006. I've shared with those in this room today, and will make available publicly, an affidavit filed by the career prosecutor in a civil matter related to the Epstein case. She talks about the challenges faced. She talks about the victims being scared and traumatized, refusing to testify, and how some victims actually exonerated Epstein. Most had significant concerns about their identities being revealed. The acts that they had faced were horrible, and they didn't want people to know about them. And she goes on to write that, quote, after the fact, people allege that Epstein would have been easily convicted. As the prosecutor who handled the investigation, she says in this affidavit, these contentions overlooked the facts that existed at the time. Her description of these facts are corroborated by the FBI case agent, whose affidavit I've also shared today. Thousands of prosecutors around the nation this week are weighing guilty pleas versus trials. These cases, as I said, are hard. They require a prosecutor to ask whether a plea that guarantees jail time and guarantees registration, to ask whether that plea versus going to trial, how do you weigh those two if going to trial is viewed as the roll of a dice? The goal here was straightforward. Put Epstein behind bars, ensured he registered as a sexual offender, provide victims with the means to seek restitution, and protect the public by putting them on notice that a sexual predator was in their midst. This case, people have said, was unusual. And it was. It was complicated by the fact that this matter started as a state investigation. A state grand jury brought that single, completely unacceptable charge. A state official allowed Epstein to self-surrender. And so it is unusual because it's unusual for a federal prosecutor to intervene in a state matter such as this. We've seen cases recently, different set of facts, different. I don't want anyone to say I'm comparing these cases, but we've seen other cases where state prosecutors let folks go with no sentence and people shake their heads. In this case, the federal office intervened before the plea was taken and said, stop. Because if that plea is taken at the state level, you're going to face serious federal issues. Today, we know a lot more about how victims' trauma impacts their testimony. And this, too, is important. Our juries are more accepting of contradictory statements, understanding that trauma-impacted memories work differently. And today, our judges do not allow victim shaming by defense attorneys. I have viewed the victim interviews. They're hard to watch because I know that my former colleagues, the men and women of my office, wanted to help them. I wanted to help them. That is why we intervened.
Secretary, a lot of people are watching this news conference, including several young women who say they were teenagers when Jeffrey Epstein sexually assaulted them. They say they went to you looking for help, and they didn't hear back from you until it was too late. Do you owe them an apology?
So you're raising the issue of victim notification. And in the documents that I've circulated, I've addressed the issue of victim notification as well. The career prosecutor in this case had a difficult decision to make. And she didn't make it alone. She made it in consultation with the FBI, and she made it in consultation with the office. The agreement that had been negotiated had an unusual provision. Even though this was a state case, the victims would have the opportunity to receive restitution. Epstein would be required to pay for them to hire a lawyer to bring a case against him, a case in which he would have to plead no contest and provide them with restitution. And the concern, and these are the words of the career prosecutor, that, quote, she did not want to share with the victims that the office was attempting to secure for them the ability to obtain monetary compensation because she is aware that if she disclosed that and the negotiations fell through, Epstein's counsel would use this to question the victim's credibility. And her concerns were not hypothetical. One of Epstein's attorneys had already asked one of the victims, quote, now tell me about when the federal prosecutors told you about getting money. And so when the agreement was signed, shortly after the agreement was signed, Epstein's counsels indicated that Epstein may not comply with the agreement. And the agreement was appealed at various levels within the Justice Department. And she details in this affidavit, an affidavit that's also corroborated by the FBI case agent, how she and he and the office was concerned that Epstein might not comply. And we would have to go to trial. And we had to weigh the issue of how much to disclose against the issue of if we have to go to trial, we want to win. We want to put Epstein away. And talking about this would allow him to make the argument at trial that their testimony was compromised. And so when it was finally clear that Epstein would comply with the agreement, she talks about how she made efforts to notify the victims, how that was a Friday afternoon at 4:15, and that she learned that the state had scheduled the plea for 8:30 the following Monday. And she talks about how over the weekend she made every effort to notify the victims at that time.
But then why are you basically saying that you feel that you did everything you could, you got the best deal you could get, and you have no regrets?
We believe that we proceeded appropriately, that based on the evidence, and not just my opinion, but I've shared the affidavit, based on the evidence, there was value to getting a guilty plea and having him register. Look, no regrets is a very hard question. At my confirmation hearing, I was asked a similar question, and one of the issues that I raised is we expect a lot more transparency today. As you watch these victim interviews, it's very obvious that the victims feel that this was not a sufficient outcome. These victims were traumatized. We can't begin to understand what they went through. And they look at this and they say, but why? And so you always look back and you say, what if? What I can say is, at the time, and I've provided a timeline, I've provided information about the individuals involved, this was the view of the office. There is a value to a sure guilty plea because letting him walk, letting what the state attorney was ready to do go forward would have been absolutely awful. You know, one of the really disturbing things about this case is there's a record here. The documents that I shared today, we've shared previously with media, yet I've seen no reference to any of these documents in the perspective of some of these prosecutors. There's a record. All these documents are publicly available and could have been pulled up by anyone in this room. And so, you know, there is a record that will, you know, I wasn't at Maine Justice. I do not have a full list of the individuals that reviewed this matter at Maine Justice. I can tell you the individuals referenced in this letter. And I would refer you to the record because this was 12 years ago. I do not have a full list of the individuals that reviewed this at Maine Justice. Well, as the record makes clear, individuals from Maine Justice were involved fairly early on and were certainly aware of it. And I think if you look at the record, it will become clear that our decisions were appealed again and again to Maine Justice.